versus Sailport Resort.
Good morning. May it please the court. My name is Tracy Carlin. I'm an attorney with Brannick and Humphreys, and I represent the appellant Viola Hope. We're asking this court to reverse and remand for a new trial as to liability and damages. And in our brief, we raised about 5 issues, but I'm going to try and stick with the top 3 given the amount of time that we have. And in my view, the top 3 is the Medicare collateral source issue, the incident report issue, and then finally the subsequent remedial measures issue. With respect to the Medicare collateral source issue, it's our contention that the trial court erred by allowing the defendants to raise the issue that Viola Hope received Medicare benefits to adjust her future medical expense damages. And the reason we say that that is an error is because the trial court apparently misinterpreted Stanley. The defendants below argued that...
Let me ask you though, unless you convince us about one of your other errors that relates to a liability claim, does an error concerning Medicare in this situation proved to be harmful since it was a total defense verdict?
Yes, Your Honor, because in the Gormley case, which is the Florida Supreme Court decision that kind of started a lot of these cases rolling on the whole collateral source issue, the court says that if the jury is misled with respect to collateral sources, in other words, they hear evidence of collateral sources that was inadmissible, it misleads the jury as to liability as well as to damages. And the reason for that is that it leads the jury to believe that the plaintiff is seeking or trying to seek more damages than they would otherwise be entitled to, which lends a misimpression as to bias or corruption on the part of the plaintiff. And also in Gormley, the court specifically said that you could alternatively lead the jury to believe that the future damages are going to be paid by Medicare, so there's no fault on the defendants that caused a legal harm to the plaintiff, because the plaintiff arguably has no damages in the future because they're going to be paid by these collateral sources. So the Supreme Court has said that this is harmful error and that the defendants have the burden of proving that it's harmless error. And in this case, it's harmful for a couple reasons. Not one, standing alone, we think just letting the jury hear about these Medicare benefits that were earned and paid for by the plaintiff. And again, the burden of proving that they were not earned and paid for is on the defendants. And they never made an effort to show that they were not earned or paid for by the plaintiff. And that's the Harrell case out of the first DCA interpreting Stanley recently to say that the limitation on the exception to the collateral source rule applies only when the benefits are unearned or unpaid for by the plaintiff. And in this case, there was some evidence in the record, albeit scant, but it was evidence that the plaintiff propounded that she had in fact worked in the past and paid into the Medicare system, so she was paying for and earning her benefits. But because the plaintiffs or the defendants didn't prove otherwise, the defendants didn't make the foundational showing they needed to make in order to introduce this collateral source evidence. I know there was a recent decision out of this court called Jorg, I'm not sure how to pronounce it, that the defendants raised in their answer brief, but that didn't change anything about who had the burden to prove that these were unearned benefits or the fact that they had to be unearned, because the plaintiff in that case actually received free Medicare benefits because he was totally disabled and couldn't work. There was no evidence in that record that those benefits were otherwise paid for by that plaintiff. In fact, the plaintiff went so far as to argue that you cannot discriminate against me because I'm totally disabled and I cannot earn or otherwise pay for the benefits, so the evidence shouldn't come in. And this court said no, in that case, because they were free to that plaintiff, the evidence could come in. But in this case, the benefits were not free. And the damage was done by misleading the jury, just as the court in Gormley has found. The problem with that was then exacerbated by the second issue that I want to talk about, which is that incident report. The incident report was a report that Ms. Hope's fiance filled out about 16 hours after the accident. She went to the front desk of the condominium and said, or he went to the front desk of the condominium and said, I just want to tell you somebody slipped and fell. And they said, here, fill out this report. So he did, and he just put a brief description of what he saw that day. The problem with that report is that it's hearsay and hearsay within hearsay. The document itself isn't really a business record. I mean, we make a very strong argument, I think, in our brief that it's not a business record, but just conceding.
Let's assume that it should not have come in.
Right.
Was there anything in the report from an information standpoint that was not already before the jury by virtue of the cross-examination that was undertaken at trial where they used the report for impeachment purposes?
Well, yes. I mean, what happened was when the defendants asked about the report, they were able to just get it admitted into evidence. And our problem isn't the prior inconsistent statement. Well, we have a problem with that. I mean, our position is that the statements are not inconsistent. What he said at trial and what he said in the report are the same, with the exception of some little nitpicky details that weren't there, right, under the Pierce case.
And nitpicky details becomes, what is it, beauty in the eye of the beholder?
Yeah, maybe, I suppose. I mean, and that's one of the things the court has to decide. But even if you find that it was a prior inconsistent statement, they couldn't admit the physical document into evidence because Mr. Anderson admitted it.
That is my question.
Right.
Assuming that should not have been admitted, was there any information in the document that was not already before the jury by virtue of the use of the document for impeachment purposes?
No, Your Honor, but I don't think that changes the harm here because, in fact, if you look at the Ellis case we cited in our brief, the court in that case had the same sort of thing, a prior inconsistent statement, and it was admitted into evidence and argued for the truth of the matter asserted. And then the court said, and that problem was made worse because then in closing argument, the proponent of that improper evidence argued it as if it was for the substantive truth. And that's what happened here. It wasn't just used for impeachment. It was put into the evidence, and the jury had it in its hand. And when they went back to argue, if you look at the record.
In closing argument, was it waved around? Was it used? Was it?
I can read you what they said in closing if you'd like, but it's also at the record on pages 998 through 1001. And it says, Mr. Anderson, as a witness in this case, Mr. Anderson saw her fall. He can't get around that. He said he saw her fall, right? He said, I saw her going over the curb, which is what he says in the incident report. He repeats, he saw her fall. He then said in his incident report that it was the truth, that he was honest, and would not have made the report if he did not believe the contents of what he saw that day. He keeps going on and on about this thing. He wrote, when we entered the parking lot, there was a curb. I said, is this the curb that you're referring to, that yellow striping? Is that the curb that you're referring to? Yes. And it goes on and on for 3 pages of closing argument.
Assuming that the report was properly admissible as impeachment evidence, is there anything in that closing that would be improper?
Yes, because he's using it for substantive. He's using it as the truth of the matter asserted. The truth is she stepped off the curb and fell.
He's summing up the evidence, and the evidence is both the impeachment evidence and the direct evidence.
Right, but the impeachment evidence is simply that he said before she fell off the curb, and now he's saying he heard a scrape and a scrape or a gasp. If he had argued it that way, I think if he had argued his statement before was just she fell off the curb, and now he's saying, there was a scrape or a gasp, that goes to his credibility. I get that. That's a prior inconsistent statement. I don't have a problem with that. What I have a problem with is that this evidence came into evidence. It was in the jury's hand. He tells them to go back and look at it, and he's arguing it, saying that's the true story. The story you're hearing today is fabricated, and that's why this is a reversible error. And if you look at Ellis, I think Ellis is directly on point on this question, because the jury then gets more weight applied to this document than they should otherwise have given it, because it was really only there to say he said one thing before and now he said something different. And so when you combine that with the Medicare issue, it makes it look like these 2 people, Mr. Anderson and Ms. Hope, A, are asking for more money than they would otherwise be entitled to, and B, are trying to collude a story after the fact. And that is seriously unfair, given the other state of the evidence that was presented to this jury. And that takes me then to the 3rd issue. I'm not sure what time I have left.
About 9 minutes in right now.
Okay. On the 3rd issue, which is the subsequent remedial measures, at this point, in the defense case, the defense brought 3 separate employees in, some of whom had been working for the property for 30 years, to say that in the history of their time on the property, there had never been any other trip or fall or incident in this particular area. The plaintiff, before trial, had filed a motion in limine and said, we don't have a problem if they want to bring in those employees and they want to say that, but if they do that, that is making an argument that that area is safe or not dangerous, and therefore the plaintiff is entitled to bring in the evidence of the subsequent remedial measures to rebut that claim. Now, in their brief, the defendants argued that somehow we were arguing that the defendants' employees couldn't make that testimony. We don't have that argument. We don't say that they couldn't bring the employees in, but once they do, the subsequent remedial measures become relevant.
So as soon as anyone says, prior to this accident, we hadn't we're unaware of any accidents or incidents at this spot. As soon as they say that, you can put up the sign that says, "Be careful"?
I think not. It wasn't as simple as that, because it was 3 different employees saying, we've been there for 30 years and this has never ever happened, nobody's ever done it. It makes that accident unique to Mrs. Hope.
But isn't this exactly what the exclusionary rule for this kind of thing is designed to prevent? I mean, we want people, if they've had the first accident they figured out about, to be able to put up a sign and say, "Be careful," and not have to worry about that coming into evidence. That's the whole policy behind it.
Well, yes, but there's also that specific exception in the rule that says if you make a claim that the area is safe and not dangerous, then the other side has the right to come in and say that's not true. And in the cases that we cited to the court, the Morowitz case out of the 3rd DCA and the Murray case out of this court, both reached the same conclusion that I'm asking the court to reach in this case, which in Morowitz, you had one witness who came in and it had to do with whether a floor was slippery when wet, right? And the witness came in and said he was unaware of any notices going to any tenants about it being slippery when wet, and then he said it's also not unsafe if the floor is wet. And then they had an expert come in and say, well,
The question is, they can come in and say, we don't know anything about any accidents that ever occurred before this one, but if they add to that, and I thought it was safe, then the sign comes.
Well, no, I think the argument, when you bring in all these people to say that there's never been any accidents, what you're saying is that the area is safe and not dangerous. And in fact, if you look at the case the defendant cited, which is Lewis versus Sun Times Corp., that court says that's...
You're only saying that they're not on notice of a problem if you say there's never been accidents before.
No.
You're not necessarily saying it's safe, you're just saying that they hadn't caught on.
No, because actually if you look at the case that was cited in Murray, excuse me. There was a Supreme Court case that was cited in Murray, and Murray cleared up the fact that that had been misinterpreted, that a no accident history can be relevant not only to lack of notice, but also to this issue of whether it's safe or not. But obviously, or maybe I'm thinking about the subsequent accident cases, but the issue in Lewis versus Sun Times Corp is that they said that a no accident history is relevant to prove that an area is not safe or not dangerous. And so that is what the whole point, why else would you bring in that testimony? There was no argument about a prior failure to warn in this case. It wasn't that at this point of the trial, there wasn't any issue about whether they should have warned her that the area was unsafe. It was that they were trying to establish through this prior 30-year history of no incidents in this area that there was nothing wrong with this threshold or this doorway, and that there's no way she could have tripped over it. Nobody else ever did. And so the whole point of these two cases, Morowitz and Murray, is to say that once you try and establish that, then the other side gets to rebut that with the subsequent remedial measures. In the Murray case, it was dealing with the champagne bottle that exploded, and the president of the company came in and said they didn't put the post-accident warning on the bottle because there was anything wrong with the bottle or that it was dangerous. They just wanted to look uniform with the other bottles. And then he also said, but it wouldn't have happened anyway unless they didn't mishandle it. And this court said, wait a minute, once you put that label, that warning label on there, the plaintiff then, once you've established that you're saying through these sideways ways, it's not because it's unsafe, but it's because we want uniformity, and two, it wouldn't have happened anyway unless they mishandled it. This court said you get to come in and rebut that with these subsequent remedial measures because that is an argument that the thing is safe. And that's the same thing we have here. And so we think for those reasons, either independently or cumulatively, this court should reverse and remand for a new trial on liability and damages. Thank you.
Okay, thank you. You've got 5 minutes for rebuttal.
Oh, thank you.
Good morning. May it please the court. My name is Scott Cole, and I'm here on behalf of the appellee Sailport. I'd just like to address the points raised by Ms. Carlin and the order she raised them, if that's okay with the court. Judge Altenburn, you raised the key issue with regard to the Medicare point that they raised. Since liability was not found, you don't consider damages. This court found that in the Jord case, and we believe that this issue should not even be considered by this court based upon that reason alone. And
but she says that in Gorley they found it to be harmful error even in a defense verdict situation. Is that true?
That is correct in Gormley, Judge Altenburn, but that is not correct what this court found in Jorg, and this court ratified Stanley. Gormley dealt with collateral sources in general, not with Medicare in specifically as this case did. And as this court knows, we both relied on Stanley, we both cited to Stanley, and Stanley had said this type of evidence can come in. And in Jorg, this court a few months ago said that it doesn't taint liability. The court made it very clear that it doesn't. And for those reasons, we don't believe the court should reach the issue.
Were we in conflict with the Supreme Court when we said that? Did we explain?
No, you weren't. No, Your Honor, this court was not in conflict with the Supreme Court. In fact, this court made a very detailed analysis of all the cases that have occurred since Stanley and found that none of them conflicted with Stanley, nor did this court conflict with Stanley in the Jorg case. I'd like to correct a few points that we disagree with counsel on respectfully. That counsel started her argument on Medicare issue saying the defendant raised the issue that Hope received Medicare benefits. We never raised that issue. As we set forth in our brief, this was a very, I think the trial court said, blink of an eye part of the trial. It was about 5 pages of an 1,100-page transcript. And all we did, all trial counsel did is say, ask their life care plan expert, hey, did you consider the Medicare rates? No evidence of any rates came in. The rates were never considered. Once the trial judge allowed those few questions to be asked, he stopped the inquiry, and it was never raised by us again. And in fact, their expert explained away the issue, which also, in our position, guts the entire issue, and it should not be considered as reversible error by this court, when she said, I don't consider Medicare rates, I don't consider insurance rates, I go by the rate that is regularly charged in the industry, because I don't know if people are going to be getting insurance next year, and I don't know if Medicare is going to be around next year. And certainly we all know with the Affordable Care Act, things have been changed, but that's exactly what their expert said. And then trial counsel said in closing argument, admittedly, as we said, in the context of past Medicare benefits, but it also sort of impugned future Medicare benefits when he said that the jury is not to consider any evidence of Medicare. So those issues were not to be considered by the jury. It was very clear to them.
It was the defense lawyer that pointed that out, closing argument, right?
It was the plaintiff's lawyer.
Plaintiff's lawyer, right?
Yes, Your Honor.
Right. So if it was a beans in the ear argument, it was done by the plaintiff's side and not by the defense side in
yes.
closing.
In fact, in closing, we did not even bring up the issue of Medicare. And I disagree with counsel under the Winston case that it's our burden to prove that Hope did not pay into the system. And this was a lady who did not present any evidence of past medical history through her own testimony or an economist. Her fiance or boyfriend, the 28-year relationship they had, said that she worked for a couple years in a flower shop. There's no evidence that she paid into the Medicare system. It's certainly likely that she could have. We don't know that. She could have during those couple of years that she worked in this flower shop, but it's not our burden. Now, the Winston case out of the 3rd District, in the concurrence, Judge Schwartz did point that out, but that's not in the main part of the opinion, so we would disagree with counsel that it's our burden. With regard to the incident report, Judge Silberman, you asked the key question here from our position, and you asked, even if it does not come in, the incident report, all the evidence was before the jury, and it was. Now, what we're trying to seek here is the truth. You see that in every trial courtroom in the state. And what occurred here? You had Mr. Anderson, who was there. Yes, Judge. I didn't know if you were going to ask me a question.
Yeah, bottom line is, do you agree? I know you didn't write the brief, if I recall, because
that's correct.
I think there was a notice about the change in lawyers at the firm. Do you agree at this point that the incident report should not have been admitted as substantive evidence?
No, I believe it should have come in because of I don't believe it's double hearsay, because the cases cited by counsel in their brief and in their reply brief, it's double hearsay when it's written. Let's say I'm Sailport Condominium, and I write out the report, and then I ask Mr. Anderson what he saw, and then I write what he saw.
So if a supermarket has a slip and fall, they can quick round up the 12 customers that are in the aisle and get them all to write down what they saw and get them admitted as business records?
No, that's different.
In any case that says that.
I do agree with you, Judge Altenburn, that no case says that, but we believe that this falls within the exception, Judge Silberman, of the cases that say it's not a business record.
It would be hearsay within hearsay if the store, or in this case the condominium's agent, had written this down.
Yes, sir.
But it's been written down by someone who is not their agent. So how does it become their business record when it was prepared by someone that is not one of their agents?
Well, counsel did point that out in the issue, but this was written by someone who absolutely had The knowledge, it was written by Mr. Anderson himself, and it was signed by
Isn't
Mr.
the
Anderson.
business records exception based on it is prepared by someone whose duty it is to prepare those documents that come in as business records?
Yes, that is correct, Judge.
And was the individual who prepared this report a person who had that duty?
That is correct. That is the business record exception.
But in this case, the person who prepared the report was whom?
Well, it was prepared by Sailport condominium individuals, and Mr. Anderson filled out a portion of the report.
It's a standard, it's a Xerox form or whatever.
Yes, it is.
The only writing on it is by her fiance, right?
No, Judge, there's writing about when the incident occurred. There's writing, in fact, we both have it. I can show the
I've
court.
got it here as well. Let me take a quick look.
We're not as technically savvy. We both
Yeah.
brought it up with us and have the same part highlighted. The details of the room number they were in, the date it was reported, the registered guest who was in the room, those sorts of things were not written by Mr. Anderson. And it was signed by a Charles Sweeney, and it was reported to Charles Sweeney.
But anything that was said to him would be hearsay.
Yes, it would be hearsay, but if we go to the,
And the thing that's a little troublesome to me about this is this comes in almost like an admission against interest by a fiance who can't make admissions against interest for Ms. Hope. And so I'm not sure whether it's the equivalent of impeachment, but I don't see how this comes in as substantive evidence.
well, Judge, I would, as I disagree with Judge Silverman, I'll respectfully disagree with Your Honor, but I think as Your Honor and Judge Silverman asked counsel the key questions, the evidence was in anyway through impeachment, and it certainly comes in through impeachment, and there was nothing in the record, in the evidence before this jury, through impeachment that was not contained in this report.
If the document itself goes back into the jury room, and this became far more of a feature of the trial than perhaps your Medicare issues. There was a lot of discussion, it seems like, about this part of the case, and the document goes back to the jury, which it doesn't go back if it's impeachment. So I'm not quite sure anymore whose burden it is in these civil cases to prove whether it's harmful or harmless, but this is at least a troublesome document.
Judge Altemert, I would respectfully disagree with you that it became a feature of the trial. In fact, counsel read the portion of trial counsel's closing argument. It wasn't a feature of the trial. All we did was say, this is what he said in the incident report, which was filled out 16 hours later, written by him, signed by him. If anything goes to truthfulness, that does. And he never said any of the things he said in trial. He never said he heard a gasp or a scrape. He never said his back was turned. He never described it in the way he did at trial. And had he have stuck to what he wrote in this report, none of it would have come in. But it was allowed to be impeachment and allowed to come in because he wasn't being truthful with the jury.
What was the evidence on liability? We focused on a number of things in this case, but were there experts that came in and said that whatever the condition was that she tripped over was a building code violation or a deviation in some fashion?
Yes, Your Honor. They said there was a threshold problem, and it was I believe it was
taken off some carpet or something, so
yes,
there
and
was
put
a
in
little
tile.
bigger lip than normal?
Yes, exactly. I believe it was 1 3/8 inch on one side and 1 1/2 on the other. And they said that those should be level, so they're off by an eighth of an inch, and also that there shouldn't have been that extra lip because of the removal of the carpet and the replacement of the tile. But that was basically it. And they also said, which he did not say in the incident report, that it was dimly lit. And that's another reason why it was important to point out what he did say immediately thereafter, not a couple years later. The trial was in 2012, so not 3 years later. With regard to the last issue raised by counsel about the subsequent remedial measure, Judge Altenburn, you again asked the key question. This is exactly the policy why we want businesses to do this. They had an accident, they put up a sign, watch your step. That certainly, a watch your step sign does not claim that an area is safe. And Judge Altenburn asked...
But has this case law begun to develop that if you take the position that you don't need any warning or repair, that if you put up a sign, it's then admissible?
I did not hear the last part of your question.
I'm sorry, but has the case law developed that if the defense puts on evidence that there is not a dangerous condition, that there's nothing to warn or change, that then it's admissible to show that you did put up the sign?
I would agree it may be admissible if we took the extra step that you pointed out, Judge, had we said, as you said, that it was okay to say you do not know about prior accidents, but if you added to it that the area is safe, that's different. That's exactly what happened in the Champaign case. They put this warning label on that said the accident could never occur like it did in the past. You said, well, wait a second, that's exactly how it occurred. We never came out and said this area is safe. We never said the accident could not have occurred as she described it. All we did was put up a sign that said, watch your step, to warn other patrons to be careful when they're exiting the building. That's all we did. Had we gone that extra step and made those proclamations as they did in the newsletter, I can't pronounce the name of the case, or the court, I call it the court case, then it may have been different, but we didn't do that. And if the court has no further questions of me, I will just ask that this court affirm the trial court in all respects. Thank you.
Ms. Harlan?
Mr. Carlin, help me understand exactly what the current state of the law is on subsequent remedial measures, because I'm really not clear, even though I've read this carefully and read these cases and listened to both of you argue it. It sounds like it doesn't exist anymore.
The subsequent remedial measure rule?
Well, the prohibition against bringing in evidence of subsequent remedial measures. It sounds like that rule is gone.
No, I don't think that rule is totally gone, but I think that the rule is based on the last sentence of the rule in 9407. It says the subsequent remedial measure exclusion does not require the exclusion of evidence of subsequent remedial measures when offered for another purpose, such as proving ownership control or the feasibility of precautionary measures if controverted, or impeachment. And so our argument has all along been that once you brought in those guys to say that there's never been an accident, that is saying that the area is safe and not dangerous. And we can impeach that by saying, clearly you thought it was.
That's a notice issue as compared to whether, I mean, it doesn't say that it's not in violation of the business code, it just, or the building code, it just is that it's never been an accident.
Right, which is saying that clearly if there's never been an accident, it's got to be a safe area. That's especially when you're going over a 30-year, 30-year term. It might be different if they said, you know, in the last 2 years there's never been an accident, but this is bringing in people who've been on this property for 30 years who say we running up and down these stairs all the time.
Been there as compared to the carpet. Is there evidence on that?
No, I don't know that we know when the carpet was replaced.
Because that apparently it wouldn't have been at least as big an issue when the carpet was there as compared to when the tile was there.
Correct, Your Honor. That is correct. So, at least as to the subsequent remedial measures, Your Honor, Judge Morris, I don't think that the law has changed that drastically. I mean, these cases are not that new. I mean, Murray and Morowitz are older cases. I think it's always been that case that if you as the defendant come in and try and through these other ways establish that the area is safe, not just by having, you know, an expert say, even though there's a violation of the building code, that doesn't mean that people will trip over this or whatever. But you're bringing in this history, this no accident history, to bolster your claim that this area is safe. Then we get to come in and say, no, that's not true because you clearly didn't think it was safe. You stuck a sign up after that and you painted the curb with a stencil and you did these different things. And so I think from that standpoint, we have reversible error there. But I think I also want to address this impeachment issue again because in the Ellis case that I referred to, Your Honors, and that's a Florida Supreme Court case from 1993, we had about the same issue. And one thing I forgot to mention before is that the court specifically said that once you offer this thing, whatever the impeachment evidence is, for the truth of the matter asserted, the court should no longer hear your claim that it was only for impeachment purposes. And that's at page 996 of that Ellis opinion. And then the court also said that it wasn't simply an attack on the person's credibility. Rather, in that case it was the state, but here it's the defendants, made an active effort to persuade the jury both to believe in the truthfulness of the out-of-court statement and to reject Fiegel's, in that case it was Fiegel's, in this case Anderson's, in-court statement. And that's exactly what they were trying to do here with this prior incident report. And I agree with Your Honor, it is trying to say this is an admission against interest. And we argued that in our brief, that this was somehow Ms. Hope got brushed or painted with this brush of an admission that she never made and never had a chance to do anything about. And so we think that that error was sufficient to give rise to a new trial. Then on the Gormley issue, I think counsel is correct. He conceded that in Gormley, the court said that this does affect both liability, the Medicare issue does affect both liability and and damages, and even though it was a defense verdict, and Jorg did not, by the way, if you go back and read the Jorg opinion, did not say that it didn't affect liability. What the Jorg court found, though, was that because none of the prior cases involved unearned Medicare benefits, that's why Jorg was distinguished. And if you look at that star 4...
Unless they said it was a per se kind of error, it seems to me that this is sort of qualitative. How much does this... There's a point at which damages stuff crosses the line and affects liability as well. But
Right.
if the only person who argued Medicare in closing argument was your attorney, not his attorney...
He didn't, though, Your Honor. He argued Medicare with respect to the stipulation by the parties and the court's instruction to the jury related to past medical damages. With respect to future medical damages, which is the issue we have here, he didn't say anything about Medicare. His statement, they are interpreting it extremely broadly, but when you look at that statement in closing, he says, I'm talking about the instruction that you're going to get regarding past damages, and you can't consider Medicare. And we're saying that you can't consider Medicare for future either. And as far as the burden of proof, the last things I'll point out to the court is that also, not only was it in Winston Towers where Judge Schwartz, in his concurring opinion, said the burden is on the defendants, but in the first DCA case, Weaver, that's cited in our brief, at the second footnote, they point blank state that to prove the factual basis in which to apply Stanley, the burden is on the proponent of the collateral source evidence. So thank you.
Thank you. Mr. Cole, we appreciate your coming up on short notice. I know it was a challenge to you, but we kind of needed to move on with the case. So.
I understand. Thank you. Nice to see you all.
Appreciate it. Nice to meet you.
So now we'll go to case number 1, which is Picano versus Picano.